Hello viewers, today's lesson is the sociological approach of Jhering, Duguit and Ehrlich. Sociological school, which is also known as functional school, believes that law is a social necessity with a social function. Patton points out the fundamental tenet of this school is that we cannot understand what a thing is unless we study what it does. According to Keaton, this school is concerned not with law in books, but with law in action. Borrowing analogy from other sciences, one can say that the sociological school deals with applied jurisprudence and not with pure jurisprudence. A jurist belonging to this school is concerned not merely with the rules of law, but also with the social forces that brought those rules into existence and with the social factors that contribute towards the observance or non-observance of those rules of law. To this school, the behavioral patterns produced by a principle of law are as important and pertinent as the principle itself. A sociological theory of law normally rests on three closely related claims: that law cannot be understood except as a social phenomenon, that an analysis of legal concepts provides only a partial explanation of law in action, and that law is merely one form of social control. This branch of jurisprudential study, which is popular in the United States of America, has so rapidly developed that many law schools offer courses in law and society and sociology of law, and also established centers for socio-legal studies. As ethical school is the meeting point and common ground for ethics and jurisprudence, the sociological school is the meeting point and common ground for sociology and jurisprudence. Auguste Comte, Max Weber, Emile Durkheim, Jhering, Duguit, Ehrlich and Roscoe Pound are the exponents of this school. Auguste Comte coined the word sociology in 1839. There are different opinions about the subject matter of sociology. It is a science of social relationships, study of social life, study of social action, study of social groups or social systems. According to sociologists, law is a social institution governing the relation between individuals and groups in a society. Sociologists point out that human beings are more dependent on social organization than in any other species. Hence, institutionalized social forms such as law and state are of considerable significance in the life of the community. The study of law in its social setting as a social institution is the basis of the sociological approach to jurisprudence. The methodology of sociology in relation to the study of law involves a close analysis of the structure, functions, effects and values of a legal system. Sociology of law and sociological jurisprudence. Jurisprudence is the science of law. It is concerned with the study of the entire body of legal principles. Jurisprudence and sociology are intimately related to each other. Sociology is the study of man in society. Law controls and regulates actions of human beings in society, and it is therefore a subject of great importance for the sociologists. There is, however, difference of approach of a sociologist and of a lawyer to the subject of law. A lawyer is concerned with the rules that men ought to obey. He is not interested in knowing how and to what extent these rules govern the behavior of ordinary citizens. A sociologist, on the other hand, is interested in law as a social phenomenon. His chief concern is not with the rules themselves, but with whether they are observed or not and in what way. A sociologist's study of law from this angle has been given the title of Sociology of Law or Sociological Jurisprudence. Sociological jurisprudence investigates how far the laws promote social welfare and the people's reaction towards the laws. It deals with the law in action and their effects and defects in relation to social progress. In an era of vast social reforms, such an inquiry deserves the utmost importance. Sociological jurisprudence may be said to make a pragmatic approach to what the legal theory makes a theoretical approach. The sociologists look more to the working of the law than to its abstract content. They regard law as a social institution which may be improved by intelligent human effort. They lay stress upon the social purposes which law subserves rather than upon sanction. For example, criminology is concerned with the systematic study of crime and criminal behavior from the social point of view. Penology studies the effects of various penal systems of punishments and the efficacy of reform and rehabilitation schemes in changing criminal behavior. These branches of legal sociology have rendered great service to the lawmakers and law executors by adding to their knowledge how the laws work and how the crime can be effectively dealt with. Sociology has thus shed considerable light and understanding on the various problems that the society must solve, particularly from the point of view of criminal jurisprudence. Sociological school attaches great importance to judicial action than legislative action. Consequently, this school emphasizes that law must be interpreted not merely with reference to the bare bonds of the letter of the law, but with reference to the spirit and the purpose of law. For this reason, judge must not be hidebound by the letter of the law, and he should be permitted the widest latitude in statutory interpretation. In this session, 3 sociological jurists are selected for comment. Jhering, a German jurist, Ehrlich, an Austrian jurist, and Duguit, a French jurist. Rudolf von Jhering. The German School of Jurisprudence of Interest, founded by Rudolf von Jhering, can be considered as an important contribution to the sociological jurisprudence. The German school believes that in every society there is a continuous conflict of interests. Social conflict is inevitable phenomenon. No society is free from conflicts. Conflicts are of different forms. Conflict between 2 individuals, between 2 groups, between individual and a group, between 2 communities, between 2 states or nations, so on and so forth. Every conflict may be seen as conflict of interests. Law seeks to resolve the conflict by providing a compromise, and this is done by law by selecting some interests for legal protection. These legally protected interests are called as rights. So, in the ultimate analysis, law resolves the social conflict by conferring rights and imposing duties. Jhering rejected the view of the historical school that law develops peacefully and spontaneously in every society. According to him, the development of law, like its origin, is neither spontaneous nor peaceful. It is the result of constant struggle or conflict with a view to attain peace and order. Jhering says, law is the guarantee of the conditions of life of society, assured by the state's power of constraint. Social utilitarianism. Jhering's theory of law was based upon social utilitarianism. Law has a social purpose. All individual purposes must be harmonized with social purpose. Law's essence could be expressed by reference to its social purpose. Law existed to protect the interests of society and interests of the individual by coordinating those interests, thus minimizing the possibility of social conflict. Jhering, in his Law as Means to an End, said, "Law is the sum of the conditions of social life, in the widest sense of the term, as secured by the power of the state through the means of external compulsion." Jhering found in Roman law a progressive adaptation of concepts to suit the changing needs of the society. From it, he deduced a theory that every legal institution must be inspired by a social purpose. He also recognized the purpose of every human action to be the acquisition of some happiness and the avoidance of some misery. That is why he was styled as a social utilitarian. He takes law as a means to an end. The end of law is to serve purpose. This purpose is not individual but social purpose. When individual purpose comes into conflict with social purpose, the duty of the state is to protect and further social purposes and to suppress those individual purposes which clash with it. This end may be served either by reward or by coercion, and it is the latter which is used by the state. Therefore, law is a coercion organized in a set form by the state. Law and the reconciliation of conflicting interests. The true aim of law is the realization of an equilibrium of individual and social purposes. If we name the purpose of an act as the interest involved in the act, we may say that the interest in every human act, whether done by an individual or by a body of individuals or by the state, is the pursuit of a happiness or the evasion of a misery. Man in society has a double role, as an individual and as a member of the society. In both the characters, he has interests. The collective society has interests. The state also, as the ultimate collective society, has interests. These interests may converge or conflict. Convergence of interests leads to cooperation and results in commerce, family relations, associations, and the state organization. When interests conflict, an adjustment or balancing of interests becomes necessary. When interests of an individual conflict with interests of another individual, a via media that concedes a fair share of interest to each individual relieves the conflict. When interests of an individual conflict with interests of the society, a balancing of interests becomes necessary on a comparison of the good and evil that may follow the acceptance of one against the other. That interest, whether individual or social, whose upholding would result in a lesser evil or larger good, must prevail over the other. The social inducement for observance of this principle are reward and coercion. Thus, a soldier is induced to serve in the army, and a trader is induced to distribute his store of goods to the people by the principle of reward. A profiteer is induced to desist from adulteration of his merchandise, and a businessman is induced to pay tax by the principle of coercion. Friedman says, the desire for reward produces commerce, and the threat of coercion makes law. Sometimes the balance of interests may be guided by a sense of duty and love. These four, reward, coercion, duty, and love, are the factors that make society stable. As social conditions vary, the balance of interests varies, and therefore law, which represents the principle of coercion in the balance of interests, also varies. The law will provide the institutional framework within which the individual's life can be enhanced. Thus, law is the mediator, the balancer, and the harmonizer of conflicting interests in a society. Jhering would say that to insist that law must be the same for all times is no whit better than to insist that medical treatment should be the same for all patients. Thus, in Jhering's conception, law emerges out of a struggle in assertion of interests. As the founder of the theory of law being a balance of conflicting interests, Jhering has been styled by Friedman as the father of modern sociological jurisprudence. Leon Duguit, Social Solidarity Theory. Duguit was another great jurist of sociological jurisprudence in the continent. He was professor of constitutional law at the University of Bordeaux. He belonged to the age of the collectivist legislation. He developed the theory of social solidarity at a period when the doctrine of individualism was crumbling in Europe, being replaced by a new philosophy of collectivism. Duguit was influenced by Auguste Comte, the noted French positivist who had expounded law as a fact and had rejected the theory of subjective rights. Comte's notion that the only right which man can possess is the right always to do his duty greatly influenced Duguit's theory. Duguit was also influenced by Emile Durkheim's work Division of Labor in Society. Durkheim distinguished between two types of social solidarity, what he calls mechanical solidarity and organic solidarity. Within early undeveloped society, men recognized the need for mutual assistance and the combining of their aptitudes. People are bound together by the fact that they have shared a common conscience. Cohesion of a kind existed which is called mechanical solidarity or solidarity by similitude. In such a society, because of the collectivist attitude, individualism would exist only at a low level. In more advanced societies, in which the division of labor was widespread, collectivism was replaced by individualism. A strong social conscience would produce an organic solidarity or solidarity by division of labor, which reflected the functional interdependence of men. Law is an index of social solidarity because law tends to reflect different types of social cohesion. Different types of solidarity produced their own forms of law. Duguit propounded a new approach to law based on the interdependence of individuals in social life. As life is lived today, social interdependence has become unavoidable. For example, our food, houses, clothes, recreation, entertainment, etc. Duguit made a distinction between two kinds of needs of men in society. Firstly, there are common needs of individuals which are satisfied by mutual assistance. Secondly, there are diverse needs of individuals which are satisfied by the exchange of services. Therefore, the division of labor is the most important fact of social cohesion. He named it social solidarity. With the development of free individual activities, the social solidarity develops. This social solidarity is a fact and it is necessary for social life. In the present day society, man exists by his membership of the society. Each man cannot manufacture and produce the necessities of life himself. The end of all human activities and organizations should be to ensure the interdependence of men. This is Duguit's doctrine of social solidarity. Law also is to serve this end. Duguit says, law is a rule which men possess not by virtue of any higher principle whatever, but by virtue and perforce of facts, because they live in society and can live in society. Duguit launched a vigorous attack on the myth of state sovereignty. The social solidarity is the touchstone of judging the activities of individuals and all organizations. State is also a human organization. They too are under a duty to ensure social solidarity. Therefore, the state stands in no special position or privilege, and it can be justified so long as it fulfills its duty. Duguit's theory of minimization of state function leads him to deny any arbitrary power to legislature. Legislator does not create law, but merely gives expression to judicial norm formed by the consciousness of the social group. Another important point in Duguit's theory is that he denies the existence of private rights. The only right which any man can possess is the right always to do his duty. Individuals working in any capacity are the parts of the same social organism, and each is to play his part in furtherance of the same end, that is, social solidarity. According to him, the essence of law is duty. Criticism of social solidarity theory. Social solidarity, a natural law principle. The facts of social life to which he confines his study in practice tend to become a theory of justice. Like natural law theories, he established a standard to which all positive laws must conform. It is nothing but natural law in a different form. Social solidarity to be decided by judges. A question may arise as to who is to decide whether a particular act or rule is furthering the social solidarity or not. Naturally, the judiciary will have the power to decide it. The judges too have their weaknesses and limitations, and this process may lead to judicial despotism. Social solidarity, a vague expression. The idea of social solidarity is very vague, and an analysis would reveal that it is not free from metaphysical notions. Social solidarity interpreted to serve divergent purposes. Social solidarity may be subjected to different interpretations which may be used to serve divergent purposes. Fascists used it to suppress trade unions. Socialist jurists used the theory to establish that individuals have no rights. His denial of distinction between private law and public law was great attraction to socialist jurists. Duguit confused ease with ought. While defining law, he confused with what the law is and what the law ought to be. According to Duguit, if law does not further social solidarity, it is no law at all. Duguit overlooked the growing state activity. He overlooked the fact that social problems of modern community can be solved better by state activity. In modern times, with the development of society, the sphere of state activity has much more widened, and the state has grown very strong. Despite defects and weaknesses in Duguit's theory, his approach is very comprehensive. Though his theory ultimately becomes a theory of natural law, the idea of justice that we find in him is perfectly in social terms and derived from social facts. He shaped a theory of justice out of the doctrines of sociology. Later jurists took inspiration from him. Duguit Ehrlich, the concept of living law of the people. Professor Duguit Ehrlich of Austria is another sociological jurist who expounded the organic concept of living law. Ehrlich, while following Savaney's line of thinking, does not hang on the past, but has his views on the present society. The living law, as conceived by Ehrlich, is the inner order of associations, that is, the law practiced by society as opposed to law enforced by the state. As Volksgeist was the central theme of Savaney's theory, the living law of the people was the pivot of Ehrlich's theory. The central point in Ehrlich's theory is that the law of a community is to be found in social facts and not in formal sources of law. In his fundamental principles of sociology of law, he says, at present, as well as at any other time, the center of gravity of legal development lies not in legislation, nor in juristic science, nor in judicial decision, but in society itself. Ehrlich differentiated living law from formal law. In other words, he brought a distinction between norms for decision and norms of conduct. Norms for decision is formal law, whereas norms of conduct constitute living law. The task of legislators, judges, and jurists is to discover the living law, he said. The law in the formal sources, like legislation and precedent, does not reflect the actual life of the people. There are many norms followed by the people and deemed binding on them, which are not embodied in the law. State is an organization of the people, but it is not the only one. There are several others like the family, the village, the chamber of commerce, the trade union. These organizations also have norms to regulate the conduct of individuals. They are strictly observed by the individual because of the social pressure behind them. They also form rules of conduct and therefore part of the living law of the people. Ehrlich says the law is much wider than legal regulations. He illustrated the gap between the formal law and the living law. For example, a commercial usage comes into practice as a matter of convenience and usefulness. Normally, it takes a long time for the court to declare it in a precedent, and a longer time for legislation to embody it in a statute. Very probably, by that time, new usage may have grown in practice. Thus, the formal law lags far behind the living law. Friedman says that Ehrlich's theory relates law more closely to life in the society. It concerns to present rather than the past and tries to analyze the social function of law. In giving too much prominence to social facts, Ehrlich has confused custom as a source of law with custom as a type of law. In primitive societies, customs were the laws, but in a modern society, a custom does not become an enforceable law merely because it is observed in practice. It ignores the fact that legislation does very often and case law does at times impose a new principle which the society follows thereafter in practice. For example, the Prohibition Act and the rule laid down in Donoghue versus Stevenson. As the welfare state extends its activities, new legislations are made to cover all possible aspects of the social life. Critics have found a number of flaws in the theory of living law. It involves studying much extra legal data and the province of jurisprudence becomes boundless. Ehrlich's approach is termed as megalomaniac jurisprudence by Professor C.K. Allen. A moderate attempt has been made in this lesson to evaluate the contribution of Jhering, Duguit and Ehrlich to sociological jurisprudence. Thank you.